started momentarily. Good morning to those of you joining us on Zoom. Takes just a minute for everyone to load into the system, so if you'll be patient with us, we'll get started momentarily. Good morning and welcome to WITA's 24th webinar in the 4 months we've been unable to hold events in person. We're delighted so many of you could join us today for what promises to be a very interesting and deep conversation on a topic that's generated a lot of friction in the trade world for over 20 years. Hopefully we solve that issue today. Yes, big smile, Stacy. Before we get into today's event, we want to make sure you sign up for our discussion next Wednesday with Congressman Darren LaHood of Illinois. We'll be discussing U.S.-China trade policy and his work as a co-chair of the bipartisan U.S.-China working group and as a member of the House Republican China Task Force. If you've taken part in our past recent events, you'll know we like to call out a few names of the people who are viewing our webinar today, even if you can't see their faces. So today we'd like to say hello to David Gantz at the University of Arizona, Matthew Schaefer at the University of Nebraska School of Law, Julia Kinn, a professor at Wayne State University, and Elaine Feldman at the University of Ottawa, who I think several of our panelists probably know very well. Thank you all for joining us today. We are so pleased to be able to reach beyond the boundaries of DC and to welcome so many of you from around the United States and around the world. Today, as baseball kicks off in the US, we have our own all-star team of trade policy experts to discuss one of the thorniest issues in global trade today, the Dispute Settlement Understanding, the DSU, and the WTO's appellate body, which has been a focus of much discussion and controversy for nearly the entirety of its 25 years of existence. Our all-star panel today will kick off with a discussion between several leading experts on the DSU, each with long experience working with the appellate body. You should have received their biographies in today's event program that was emailed this morning, and we're incredibly pleased to welcome them here today, starting with my good friend Rufus Yerxa, the president of the National Foreign Trade Council and a former deputy director general of the WTO. He'll be joined by Stacey Ettinger, who has represented the U.S. in more than 30 cases at the WTO when she was at the Commerce Department. Bruce Hirsch, who I think helped write one of the USTR's first briefs on the DSU and the appellate body when he was at USTR. And Ignacio Bercero, who was there from the beginning, I believe, at the creation of the WTO, and is a principal advisor for the DG Trade for the European Commission. Also for today, you've seen that we're going to debut a new feature by bringing a few audience members on stage after our panel discussion. So while today's panel will run much like a lot of our other panels with discussion between our panelists and then Q&A with the audience, when we normally close the event on the hour, we're going to extend today's sessions by about 20 minutes and bring on camera 4 more trade all-stars who are experts on the WTO in our audience. Jennifer Hillman, who is a former member of the WTO's appellate body, Ron Lorenzen, a former Principal Deputy Assistant Secretary of Commerce, Warren Murayama, former USTR General Counsel, and Terry Stewart, author of the blog Current Thoughts on Trade, and one of America's most thoughtful and respected trade litigators. All their biographies are in your packets. If you want to log off at noon, go ahead, but if you want to stay on for more in-depth insider discussion, we hope you'll stay. As a reminder, please use the Q&A tab on Zoom to submit any questions you may have for our panel. We'll try to get to as many of those as we can before bringing in Jennifer, Ron, Warren, and Terry. And with that, I'm going to slowly talk and bring Rufus back on camera. With that lengthy introduction, I'll turn it over to my good friend Rufus Yerxa. Thank you, Rufus, for joining us today, and everybody else.
Thank you, Ken, and thank you to our 3 panelists today and our 4 guest speakers at the close of this. I hope to run this, if this is a baseball game, I guess I'm kind of in the umpire role. So I'll try to make sure that the players get to play a good game and not call too many controversial calls. But let me start by asking if the audience will indulge me just a moment, these three panelists, I'm not going to give complete introductions to them, but I do want to point out their long experience in this field. Bruce and Stacy, both as senior legal officers in the US government, Bruce at USTR and Stacy at the Commerce Department, heavy involvement in dispute settlement, Bruce doing so at the mission in Geneva, as well as the head of dispute settlement in the USTR. Ignacio, a long background. I think Ignacio and I first met in 2002 when I was appointed for the first ever official mediation by the WTO in the Cantuna dispute, and Ignacio was representing the European Union in that matter, but obviously a long involvement as a director in the European Commission, chief negotiator for TTIP, heavily involved in WTO negotiations and dispute settlement. And I think the paper you wrote more recently as well, you were taking a year as a fellow at Oxford, a year leave from the commission as a fellow at Oxford, correct, Ignacio? And now I think you're going back to the commission, where I'm sure you'll play a very critical role in helping to overcome these differences that now exist in the dispute settlement area. So it's great to have all three of you there. And I'm going to get to you as quickly as possible because I want to hear each of you, your presentation on your thoughts. I want to start with a very simple and straightforward statement by one of the Director General candidates in the recent round of interviews. And I won't tell you the name of the candidate, but it's someone who said, any rules-based system will lose credibility over time if it doesn't have an effective mechanism for resolving disputes over the application of those rules. It's a fairly simple statement, but if you think about WTO and its applicability versus some other areas of international rulemaking which don't have effective dispute settlement mechanisms, I think, for example, of international labor standards under the ILO agreements and other things. So I think with that, what I'm going to do is turn to each of the three of you in order to give your presentations, ask you to do it in about 5 minutes each on any aspect of this you want. Obviously, Bruce and Ignacio have recently done, Bruce has actually done 2 papers, Ignacio's done a recent paper. But I'm going to start with Stacy, who I think we have asked to sort of play the devil's advocate here to sort of present a critique, the critique that has led to this impasse. And then I'll go next to Ignacio and then to Bruce. So Stacy, over to you first.
Great, good morning, everybody. Thanks to Ken, Diego, and WITA, and thanks to Rufus for the introduction. Yeah, I think I'm gonna sort of set the stage, I think, and then I look forward to hearing from my colleagues on the panel. So I'm gonna talk about briefly, in my short allotted amount of time, the backdrop for growing dissatisfaction with the dispute settlement mechanism, systemic concerns, substantive missteps, and then sort of the challenges of a changing world, all of this playing into the impasse that we're at now. So the backdrop for growing dissatisfaction, when you think about the explosion of and the increased demand for dispute settlement, in some ways it has been a huge success, but it also has weighted, it's weighted down the system. In part, it's extended the time for resolving disputes, which may be frustrating to members. But then you get into more substantive issues like the appellate body and panels treating prior appellate body reports as precedent. You have panels and the appellate body filling in ambiguities or gaps and omissions in the WTO agreements. And of course, those gaps and ambiguities are the norm when you negotiate a multilateral or any agreement, and you are trying to find consensus. So the other big picture, imposing additional obligations that members didn't feel they'd bargained for, and the flip side of that, diminishing sort of rights that members thought that they had gotten in the context of the agreement itself. And then the big, a big challenge of dealing with, let's be frank, China-related issues, things like subsidies in non-market economies, and is the agreement prepared to address those issues as written. So some of the systemic concerns identified by the United States, but also by other member countries, appellate body members serving past the expiration of their terms. And of course, at this point in time, it's a bit of a moot point, so we do not have a functioning appellate body, but we have the appellate body going beyond their mandate in terms of interpretation. And I know, Ignacio and Bruce are going to talk a little bit more detail about these things. Again, I mentioned treating prior rulings as precedent, adhering to precedent despite different facts and circumstances. So in cases where the appellate body has made a decision and we have a new case that's come along where the facts are and the circumstances are very different, not accounting for that difference in sort of changing their analysis on particular issues. We have the experience of the appellate body doing a de novo review of facts. It's not really their role to do so. That's the panel. The panel's job is to sort of set the factual scenario. The appellate body exceeding its mandate to review issues of law in a panel report. They're going beyond perhaps the issues that are teed up in the panel report to, ideas, sort of legal issues that they themselves may want to address or think should have been addressed, and applying new legal standards regardless of what parties argue. So this is where, the parties to any litigation, dispute settlement will decide what legal arguments they want to make. And it's not really for the appellate body or, even a domestic court to decide that they have a better legal theory and they want to decide an issue on a theory that the parties didn't argue or didn't raise. And in the end, you end up with advisory sort of opinions that the parties didn't raise certain issues or the facts aren't ripe on certain issues, and you have the appellate body sort of issuing decisions or opining on issues that no one wanted them to opine on. So many of these sort of substantive missteps have occurred in the trade remedies area, which is, essentially by far the largest overall, those agreements, the dumping agreement, the subsidies agreement, and the safeguard agreement, by far generated the most disputes overall, if you lump them together. We're not going to do a deep dive on these, but I'll just mention some of the hot button issues. So in the context of the dumping agreement, two big issues of concern to the United States in particular, but to other member countries as well: the special standard of review in the dumping agreement that was not interpreted in the way the United States thought it had negotiated those provisions. The issue of zeroing, we won't go down that rabbit hole, but has to do with dumping margin calculations. And then in the context of the subsidies agreement, we have somewhat more recently issues related to the interpretation of the concept of public body, issues related to and sort of appellate body interpretation of and reading in new obligations related to looking at benchmarks in the context of subsidy cases, and then also reading in obligations related to the specificity component of looking at whether a subsidy is countervailable. Last but not least, put this in context of the changing world that we're living in. And, even though the WTO was not negotiated and, that long ago, a lot has happened. I mean, leaving aside the sort of pandemic, which is newly upon us, which is causing its own types of problems, think about the explosion in global commercial transactions driven in large part by digital commerce. And, that just, the changes in the past, 20, 25 years is incredible. Data trade as well is also an issue that is relatively new and, not necessarily completely contemplated at the time the WTO was negotiated. I mentioned China, the issues related to China and the type of state-directed model of economic development that perhaps doesn't fit neatly in the current sort of WTO rules-based system, not really anticipated. And other issues related to intellectual property, again, data localization issues, Again, these are newer issues, and so perhaps the agreement needs, aside from the dispute settlement part of it, to be updated and modernized. You also have issues related to developing versus developed country and how they differ perspectives. You have in the current, with the current U.S. administration, you have a clear sort of mentality of unilateralism, right? It's decoupling from the global system, from global institutions, in the diminishing regard for WTO rules or other sort of rules-based sort of global rules-based institutions. And that's sort of fueling this trust issue amongst trading partners, former allies, former friends. And, hopefully that needs to change because it underlies everything. I mean, if you have a trust gap, I think as Bruce maybe referred to it, if you're not engaged in mutual sort of discussions, then it's very hard to resolve these major issues. So thank you very much. I'm going to turn it over. I guess Ignacio is after me, right?
Thank you, Stacy. Yes, go ahead, please, Ignacio.
Yes, hello, Rufus. I think it's a pleasure to be here. I will focus my presentation to essentially on trying to identify what could be points of convergence between the United States and the European Union on the issue of how to reform the DSU, and in particular to respond to the current situation relating to the appellate body. I do that because I think for me it's very clear there will be no possibility of finding a way forward on this issue unless the United States and the European Union can develop a common perspective. To a certain extent, we were jointly responsible for creating the dispute settlement understanding, and it's going to be our joint responsibility about finding the ways to fix it. Now, I will clarify that what I'm saying is a personal perspective. I'm not speaking on behalf of the European Commission. It's my own reflections arising from the paper which you have referred to, Rufus. My paper, of course, is much broader because I think it would be a mistake to think that the only problem relating to the WTO is dispute settlement. I think there's a much deeper problem relating to the negotiating function. So what I think one should aim to do is what I call a two-step approach to reform of dispute settlement. A first step, which should be work between now and MC12, should aim at responding to the key systemic concerns that have been raised by the United States. The second step should be a broader exercise of WTO reform launched by NC12 that should also look into the problems of substance that go beyond the dispute settlement function. For instance, it should look into the question about how to improve rules on industrial substance. And giving that as an example is not the only one, but this is the sort of issues that would need to be tackled as part of a broader process of reform. Now, what are the elements which I think it should be possible for the United States and the European Union to come to a convergence? I would say fundamentally 7 points. The first one is the principle of judicial economy, meaning that both panels and the appellate body should only make a ruling on those issues which are strictly necessary to find a solution to a dispute. This should be reflected in clear terms, in language agreed by WTO members. The second issue comes down to this question about what is the proper role of panels and what is the proper role of the appellate body when it comes to factual determinations. In my view, there are two things that one should do. One would be to give a very strong encouragement to panels to fully make use of their powers to establish the facts to a dispute. And the second one would be to make clear that only in most extraordinary circumstances should the appellate body review a factual determination and that would only be in cases where it's clearly an egregious effort. The same point is non-binding precedent. I think we should all agree that there is no such a thing as a stare decisis in the WTO system, and we should be able, therefore, to make clear that if in the context of a particular dispute, one of the parties raises issues of substance that imply a different interpretation to the one that had been followed previously by a panel or by the appellate body, a panel or the appellate body should address those issues of substance. It should not be satisfactory simply for them to say, we have decided this way in the past, this is the way that we are going to decide at this point in time. The issues of substance raised by the parties should be addressed. The fourth point is timeliness. And again, I would say timeliness not only on the 90 days relating to the appellate phase, timeliness also on the panel phase. Actually, most of the delays in the dispute settlement procedure have to do with the panel phase rather than to the appellate body phase. The fifth principle is accountability. I noticed, Rufo, that it is something you want to discuss in more detail, so I will just flag that one needs to identify a means to have a meaningful discussion between the appellate body and WTO members. There are different ways to structure that. One possible idea on which I have been reflecting after I wrote my papers, which is not reflected in the paper, would be the appointment of a small group of high-caliber independent lawyers that will be responsible for producing on a yearly basis a report on WTO case law. And this would also include possibly some issues in which they may include some questions about rulings which have been presented by the appellate body. Now, the key question is how you will select those limited high-caliber lawyers. One idea would be, let's focus on those countries which make most use of the DSU, and each one of them would appoint someone who corresponds to these characteristics. And let's have this group of qualified lawyers presenting a report that could provide a basis for an interaction between the appellate body and the members. Now, there have been other ideas about this issue of accountability. This is just one which I would like to mention. The sixth point is one should be ready to look into some degree of restructuring of the appellate body secretariat. Let me be clear that I think you need to maintain a separate appellate body secretariat. It's very important to avoid that you have the same line of command to the secretariat that services the panels and the appellate body. But it should be possible to think on issues like term limits for both the director and the members of the appellate body secretariat, or even the possibility for the members of the appellate body to select within the appellate body secretariat one person who would be working directly for that member of the appellate body. Final point is legal form. The question has been raised, what are the guarantees that the appellate body in the future is going to be respecting these rules? Quite frankly, I think after having had a near-death experience, I would find it very difficult to imagine that an appellate body would not be particularly mindful to respect those rules which have been agreed by the members. But to avoid any misunderstanding, I think it would be important that these principles are reflected in legally binding provisions, most likely in the form of an Article 9.2 interpretation of the DSU. Now, I think that on those 7 elements, there will be certainly a lot of discussions on details, but I don't think it should be so difficult for the European Union and the United States to develop a common view. And my impression is there's a joint view on this issue between the United States and the European Union. It should not be so difficult to persuade other members to move in that direction. And as I said, this should be leveraged as part of a broader exercise of WTO reform, which is the reason why I think it's important to get this issue ready for the conclusion by the time of MC12, which should really be the moment to launch a broader negotiation that looks more into the problems of substance, including, why not, some of the issues that related to the functioning of the dispute settlement understanding, which are perhaps more complicated, more difficult to solve in the time frame which I have now presented to you. So I think I would leave it there. but happy to come back.
Thank you, Ignacio. Yeah, we'll follow up on many of those points in questions. So Bruce, over to you.
Thank you very much, Rufus, and thank you, Ken and WITA, for having us. I think that the first point that I would make is that I agree with the Director General candidate on the importance of having a functioning dispute settlement system. Whatever its flaws, it has resolved disputes and it has caused members to take their obligations more seriously. So I do think it's important to restore it. And it's also important from the WTO's perspective to restore it, simply because the current situation has created a negative impression or deepened the negative impression of the organization's ability to get things done. And at a time when it is trying to develop new rules and deal with the coronavirus crisis, it's important to rebuild momentum, and resolving this particular issue would help in that regard as well. I do think it's also important from the US perspective, both whatever one might think of its shortcomings and its inability to deal with the lack of new rules with regard to China. It does resolve disputes. It does so without trade wars and the costs associated with those. But also, from other perspectives, it's important. And I would say that I think it's important in developing an effective China strategy, because I think that there's an appreciation right now that an effective China strategy involves allies, and our allies would prefer to deal with disputes with those allies through dispute settlement at the WTO rather than trade wars, but also they're supporters of the WTO and the dispute settlement system. So it's important to clear away this issue so that we can have better cooperation. At the same time, any kind of reforms do have to be made on a sustainable basis, politically sustainable. Stacey alluded to and referred to many of the concerns that the U.S. has had. They're not just U.S. concerns; other members have had them. It's certainly been bipartisan here in the United States with regard to those concerns. The Hill shares those concerns as well. And basically, they stem from the fact that the original conception of the appellate body was a limited one to review and correct panel legal errors, and to do so quickly. And if we're going to rebuild a sustainable system, then I think we need to go back with that overriding principle as the ultimate objective. There's been decent and good work already done in Geneva over the past year and a half. Ambassador David Walker, the General Counsel Chair, then facilitated last year a discussion where he really did help to educate senior officials and leaders on these basic points of concern and move the body a good deal towards consensus on these issues. And so what I would say is that while I agree with Ignacio on the absolute importance of, or the value rather, of having the US and the EU on the same page from the get-go, to a large extent, a lot of the basic conceptual work has already been done at the high level, and that we're left in the situation where there's a need to flesh out the Walker principles in a manner that the US will view them as, in fact, legally effective and effective in creating guardrails. And that, I would say, it's not necessarily requiring US involvement at this point, though obviously it would benefit from it. There are other members who have these kinds of concerns and issues. And above all, once this framework has already been established, which it has, the work to some extent is technical on fleshing it out. I have, for NFTC, done a couple of papers that attempt to flesh out several of these items. Just briefly walking through them, I propose that the deadline for the appellate body to complete its work within 90 days be given teeth by requiring either that the parties to a dispute agree to go beyond it, and if that is absent, then either party can adopt the report immediately as is, the panel report, without the appeal proceeding. That would help to focus the appellate body on that core task of helping to resolve the dispute, of correcting panel legal errors. It would help to avoid the kinds of advisory opinions or straying into fact finding that we've been discussing. Also, I would propose guidance that more directly to the adjudicators, to the appellate body on several of these points, including on precedent, including on the proper interpretive approach, or let me back up and just say, including on precedent, including on advisory opinions, but also on this issue of the proper interpretive approach when in fact there is ambiguity in the agreement. And what I'm proposing there is that we recognize these situations of ambiguity as ones in which members chose to use general and broad language. And what we've seen is that the appellate body is often, in the interest of trying to provide specificity in these commitments, has in fact changed the scope in a way that members didn't intend. And my guidance would suggest that the appellate body respect the general nature of these terms and not engage in that kind of activity. Also, I suggest guidance on the general role of the appellate body and of adjudicators, which is to resolve disputes and avoid some of these other tasks that we've mentioned. Finally, I propose the kind of structural change to the appellate body secretariat that Ignacio just mentioned. I propose that it be replaced with clerks who have been seconded from the main WTO secretariat for a period of a couple of years. And the purpose there would be to restore the balance of decision-making back to the actual appellate body members while ensuring that the advice which they're getting reflects an appreciation of how these agreements were negotiated and implemented, as well as the member-driven nature of the organization. And I think that using secretariat clerics or officials who've been seconded helps to really carry that over, because that is in fact deeply inculcated in the secretariat. One thing I would say, further in response to Ignacio's proposals is I think one of the greatest barriers and hurdles to date in resolving this issue has been really a gap of trust. And it is played out in particular between the US and the EU, with many doubting the US interest in actually resolving the problem. But on the other side, and here in Washington, a lot of skepticism about whether the EU really is committed to true reform. And in that regard, I think that Ignacio's paper and his suggestions today are extremely important in signaling that there are at least some in Europe who are interested in reform. It's genuine. Obviously, it would be helpful if these positions, these wonderful ideas that Ignacio has would be adopted formally by the Commission. That would further reinforce that this trust gap is really not justified. But I do think that these are important steps forward, and a lot of them really bear a lot of very close examination. I'll stop there.
Thank you very much, Bruce, and thank you all for excellent opening statements. As I said earlier, there's way too much here for us to possibly cover. These are issues that take months and months and months of discussion and negotiation, years maybe in some areas, to resolve. So, the best we can do is kind of give people a picture of what the core issues are. But I'd like to go back to this. I'm going to ask each of you to comment in turn. I'll go in reverse order of your original presentations. On a little bit, I'm combining the issue of correcting the jurisprudence, dealing with how to correct, what people feel has been overreach in the jurisprudence, and also, things like the role of precedent and issues such as that. So that whole basket of issues before we turn to some of the issues about independence. And, I'm looking at Ignacio's paper where he talked about, there is questions about Article 17.6. Stacy mentioned that. As the person who was the US negotiator in the green room when that bargain was struck, I remember very well the discussions and the work leading up to that. I'm painfully aware of that whole history. But Ignacio, you said something in your paper that I wanted to quote here, that, quote, "It would be useful to have more discussion as to the merits of further clarifying the standard of review applicable either in trade remedy cases or more broadly." So I think maybe we can talk a little bit more about that. And Bruce, obviously you talked about this a lot in your first paper. In your second paper, you talked about making more certain that there was no binding precedent to these rulings and that future appellate body rulings could correct mistakes from the past, and that the role of the appellate body was to assist the parties rather than making laws. So I wanted to go now in reverse order to drill down a little bit on this issue of scope of review, role of precedent, the jurisprudence problem versus the other problems like timeliness and independence. So start with Bruce, and then we'll go to Ignacio, then Stacy. And once again, this has got to be 2 or 3 minutes each because we're going to have to turn it over to the wider audience in a few minutes.
Thanks, Rufus. I think that this really is at the heart of the concern. I think that the solutions to it don't necessarily have to be the direct ones, as I mentioned. If we reduce the amount of time back to what it was intended to be for the appellate body to do its work, you resolve a number of these other issues as well, including the ability to move beyond the role of the appellate body. But in terms of the standard of review, it is a critical one for the United States. It's going to have to be addressed in some way, shape, or form. I think that you're right to link it to the precedent issue, how the group is ultimately going to be dealing with some of these past findings and rulings that the United States considered to be an error is going to be an important one. It can be either dealt with through making clear that past decisions are not binding precedent and relitigating them, or it can be dealt with directly, as Ignacio is suggesting, and actually renegotiating or reaffirming them on the part of the membership. We'll have to wait and see, how that discussion plays out, but I think it is important. And on a forward-going basis, having greater clarity on the standard of review viewed broadly. And again, in the first paper, I was not per se suggesting a standard of review. I was suggesting that there be a greater respect for the text, which is more broadly applicable than even standard of review. But the point was that the appellate body, where there are broad terms, in particular in the area of trade remedies, where members negotiated with a recognition that different members implement the trade remedies differently, that there be scope for different approaches, and that the broad terminology was often chosen with that in mind. So yes, very clear statements on precedent and on this are important.
Good. Ignacio.
Yeah, first on the question about correcting the jurisprudence, for me it is quite clear that the main concerns relating to jurisprudence of the appellate body have to do with some specific rulings relating to trade remedies. Now, correcting that, of course, inevitably would imply a negotiating effort. It's not going to be simple. It's going to take some time. And I think it's also going to require identifying clearly which are the priorities. Now, if you want my own perspective, it seems to me very clear that the public body jurisprudence of the appellate body is wrong and needs to be corrected, because if it is not corrected, it very much limits the effectiveness of the countervailing duty instruments. So I would fix that as the top priority in terms of an area where you need to correct jurisprudence. Now, on the other extreme, if you look into issues like unforeseen developments in the safeguards agreement, or some other aspects relating to causation standards. Now, I disagree with the rulings of the appellate body, and I could enter in long reasons why I disagree. Is this, however, a critical issue? Is this something that needs to be corrected as a matter of priority, or is it something that may depend more of a broader context? In any case, this correction of the jurisprudence could only be part of what I call a second step of the exercise, where you discuss not only some changes of the procedures relating to the DSU, but where you also discuss a number of limited issues of substance. Now, on the standard of review, quite frankly, remained a little bit undecided about what it is to be done, because quite frankly, it's an extremely complex issue. You cannot look at this exclusively from a defensive perspective. You also need to look at it from an offensive perspective, particularly one is thinking about broadening the standard of review beyond the special standard of the anti-dumping agreement. So I think there will need to be a conversation about the pros and cons of having a somewhat more clarified standard of review. I mean, I see no problem, of course, about reaffirming the importance of 17.6.2. Now, whatever one thinks about the substance of the rulings of the appellate body on the issue of zeroing, but it's clear that it was unsatisfactory that the appellate body did not have a sufficiently substantive discussion about the standard of review, that this issue was treated somewhat lightly. So I understand why this generates a lot of concern in the United States. Now, going beyond reaffirming the system standard of review in the first stage, I think it's going to be complicated. And I think that in any case, as I said, one needs to look at this from a broader perspective, even if one is looking exclusively at the issue of anti-dumping. Do we want to have unfettered discretion for investigating authorities? If one looks into recent decisions by China or India on the anti-dumping front, do we want to have a standard of review, which means that no matter what possible interpretation is developed by an investigative authority, if this should be accepted? So I think for that reason, I agree that this is an important part of the discussion. I'm just not sure that we have found yet what would be the right approach to tackle the issue of the standard of review.
Okay, thank you. Stacy.
Sure. Very quickly on the correcting jurisprudence, I think it's there are practical issues there, and it is I think as Bruce said, you're basically either relitigating or you're sort of renegotiating, and I think from my perspective, I think the two would have to sort of move along in parallel, because as we've seen, sort of negotiating, changing the WTO, I mean, that's gonna take a long time. So I don't think there's a lot of patience for, I mean, I think it should happen, but I think that if there is consensus that the role of precedent is not binding, and at that point you make clear that the appellate body does not need to stick to its prior decisions, that there may be situations where it's appropriate to change your mind. I mean, the example I give, which is not necessarily always the best, is the U.S. Supreme Court changes its mind, right? That is the highest court in the United States, and they will do an about face on issues. So, if the Supreme Court can do it, I think the appellate body can do it as well. On the standard of review, and Ignacio's point about concerns that it could lead to giving unfettered discretion to investigating authorities. I think part of this is that standard of review is something that American lawyers and trade lawyers are somewhat comfortable with. We live with that sort of Chevron deference concept on a regular basis. And so I understand why it can be sort of misunderstood, or the concerns of a slippery slope. But I do think that properly understood, it's not intended to give unfettered discretion to investigating authorities, but rather to allow for the fact that, even overarching in the terms of provisions of the WTO, there can be reasonable interpretations of the same provision, and those interpretations can be different. As long as they're reasonable, then there should be some sort of deference to the investigating authority, but it's not unfettered. So I will stop there.
All right. Now, I was hoping to do a second question, but Ken, I'm looking at the clock and realizing that we only have about 15 minutes for the audience. So maybe, the question I was going to ask was going to go to the issue of independence of the Secretariat and some of the ideas on staffing.
Rufus, why don't you go to that question first, because we actually don't have that many questions in the queue yet. Want to remind
right.
people who are watching this, if you'd like to submit questions, use the Q&A tab and write those, and we'll try to get to as many of them as we can before we bring in our additional guests. Rufus, why don't you go ahead with that question you have?
All right, so to me, this gets a lot to this whole question that Ignacio explored in his paper, the balance between independence and accountability, because how you staff the Secretariat for the appellate body, for its writing of jurisprudence and for its decision-making is going to be important. There are obviously a variety of ideas here, and I won't try to cover them all. I mean, it's clear that there are some differences. Ignacio in his paper, for example, talked about maybe having terms for the limited terms for the director of the division. Bruce actually talked about the idea of having clerks from the regular Secretariat assigned on a temporary basis, presumably on a rotating basis. There are a number of other things about staffing, and Ignacio now has introduced other issues about accountability, like this idea of an independent board of jurists to report on the jurisprudence and other things. So I wanted to give each a chance to sort of drill down a little further on those particular points. And here, I think, Ignacio, I'll start with you, but it's got to be fairly quick, and then go to Bruce and Stacy if we have time. You're muted, Ignacio, you're muted.
I think it is important to maintain the distinction between the Appellate Body Secretariat and the WTO Secretariat that services the panel phase. So that's why I would not be favorable to the suggestion that Appellate Body members should take clerks from the WTO Secretariat. At the same time, I see no reason why it should not be possible to structure the Appellate Body Secretariat in a somewhat different manner, with both term limits and the possibility for Appellate Body members to select within the Appellate Body Secretariat one person that would be basically, if you want to use a US term, act as the clerk of that particular Appellate Body members. I think we should avoid too much micromanagement, but we might use some restructuring of the Appellate Body Secretariat would be necessary. The second idea is more to the question about how to ensure that there is a meaningful dialogue in which the Appellate Body has to respond also to critiques about its decisions. I mean, to a certain extent, you could say that's what the members do themselves when they actually speak their mind in this dialogue with the Appellate Body. But I think it would have a stronger value if you also had some independent legal opinion which looks into the rulings of panels and the Appellate Body, looks into the way in which this legally binding decision is being implemented and is being produced as an important document that guides or that helps the discussion between members at the Appellate Body. So this is an idea which I think is probably also connected to something which I believe Jennifer Hillman has mentioned, the idea of some form of oversight commission. The difficulty is how you select the members, and that's why I thought that one possible idea would be to say, let's have a small group, 6 independent lawyers. Let's identify who have been the 6 WTO members that have made greater use of WTO dispute settlement, and each one of them could actually appoint one of these members of this group for a limited period of time.
Good. Yeah. Last word, Stacy, on this.
Sure. I think for me, the first step is acknowledgement and recognition by WTO members that this sort of stagnation in the Appellate Body Secretariat is a real issue. I think at that point, there are many thoughtful proposals on how to fix that issue or how to address that issue. And for me personally, some combination of, there is a value to having institutional knowledge and memory. So I think there is a value in having professionals in the Appellate Body Secretariat, but I would weight that against, again, others has said this, an independent clerk that the Appellate Body member would also have to weight against that institutional knowledge and perhaps that set mindset to have their own clerk of their choosing And I think that would help the process. It would bring more thought into that process and not make it weighted in one way, in one direction or the other.
And Bruce, lastly to you, just for your final.
Yeah, very briefly, because I see we have other questions. I guess on the issue of clerics and whether that would harm the independence of the appellate body. I mean, so long as the clerics are reporting to an individual member on that basis, and they're supervised, so long as the appellate body member has the final decision, which this would promote, I'm less troubled by the Secretariat and as a source for clerics. And in particular, I think it's important that you have, whoever the clerk is, someone who understands the negotiating process as well as the culture of the WTO.
Okay, thank you. Ken, you want to bring in the wider audience now on some questions?
Thank you. I will do that, but I actually do want to bring up something I remember from my days in Congress, dating myself 25 years ago. But I found the WTO Dispute Settlement Review Act that was introduced in the House of Representatives in April of 1995. So very early on, and it requires this commission to determine whether the appellate body has exceeded its authority, added to the obligations of the rights of the United States, acted arbitrarily, capriciously, engaged in misconduct, and deviated from the applicable standards of review. Just to point out that these ideas go back to literally to the founding months of the WTO. And I have a feeling that the current U.S. Trade Representative, Bob Lighthizer, may have been somebody who was involved in helping get that off the ground, or that idea tabled back in those days. So my first question comes from Matthew Schaefer at the University of Nebraska School of Law. I'm going to read it off. Will dispute settlement reform involving reinstitution of the appellate body in reality occur in advance of making progress on China issues? Or do the politics signal reinstitution of the appellate body await clarification of those rules? Ignacio, I think you indicated you might want to answer this one, but you're muted at the moment.
Yeah, no, absolutely, because I think it comes down to something which is quite critical. In my view, it would be a big mistake to let the current situation fester for too long. We basically have now a dysfunctional dispute settlement system in the WTO. We have a fragmented dispute settlement system in the WTO, with some countries with the multi-party interim arbitration agreement having found a way to maintain the two-step binding dispute settlement. If we let the situation fester for too long, I think at least four things are going to happen. The first one is that increasingly countries are going to come to the view that compliance with WTO disciplines is an option. It's going to be increasingly difficult to convince countries to respect the rules if there is not a functioning dispute settlement system. Secondly, I think inevitably, disputes between the United States and the European Union are going to become extremely hard to manage, and they are going to soon deteriorate into tit-for-tat escalation. I think we are also losing, quite frankly, an element of leverage vis-à-vis China. Now, I would totally agree with the question that getting China to negotiate on the substantive issues is critical, and that's why I say you need to be able to get an agreement in MC12 to launch negotiations on issues which are critical from the point of view of how to handle China. But we should not forget that we can also use dispute settlement offensively vis-à-vis China. And by not having a functioning dispute settlement system, we are giving up an important source of joint leverage vis-à-vis China. So for all of those reasons, I don't think it would be a good idea to take a vacation from binding dispute settlement and to wait until we have sorted out all the issues that need to be negotiated on substance. Those are issues which are not going to be solved very quickly. I think you need to have a reasonable time frame to come to a conclusion on negotiations on issues like subsidies, digital trade, etc. But it's much better to do those negotiations from the perspective that we have at least agreed to restore for 4 years the appellate body. And that's why I talk about this two-step approach to dispute settlement reform.
Thank you. And as a follow-up question, Ignacio, there's a question about, and I think Rufus, this maybe go to you as well, based on your past experience. I know you're a moderator, but you're also an expert in these issues. But is a disabled DSU something that maybe lends itself, because it needs to be negotiated, to helping further enhance maybe and bring back the WTO's negotiating mandate, which is certainly one of the things that the United States believes, that some of these disputes need to be settled through negotiations rather than dispute settlement.
You want to take that first, Ignacio, or do you want me to, Ken?
Ignacio, you're muted.
You're muted.
Let me just say very briefly that I have never been very convinced about that argument. The reasons why the negotiating function is not functioning in the WTO are deeper. They have to do with disagreements among the members. They have to do with the rigidity of the institutional structure for negotiations. Doing away with binding dispute settlement is not suddenly going to solve the problems attached to the dispute settlement function. So I would argue one should try to fix the dispute settlement first, and then, of course, at the same time, launch this process of negotiations.
I would only say, Ken, that, I think the risk of a breakdown, the risk of unilateral actions can be used to a certain extent as a lever in getting reforms, which is, that depends. I mean, obviously, there was some of that during the Uruguay round, but I would also say if it goes too far into a breakdown of the system, and part of the problem is some of the people involved in this debate now maybe are not as concerned as all of us in this audience are about making sure that a system of rules doesn't lose its credibility. Because in the long term, rampant unilateralism is not in the better interests of most of the commercial interests around the world, including in the United States. So, it can be used as some kind of a lever to push for greater reform in areas that aren't covered by the rules, but we ultimately have to resolve this matter if we want to have a rules-based system.
Bruce, I think you wanted to weigh in on this.
Yeah, just briefly. I mean, I think that, this is relatively speaking, low-hanging fruit. And the opportunity should be taken to make progress on it, to fix it, to build momentum for other areas. And I don't think that it would interfere with progress in other negotiations, so long as the guardrails are put in place that make clear that you can't use the system to get through disputes what you want, you need to get through negotiations.
Stacey, were you looking to jump in?
Yeah, just real quick. I mean, I'm not disagreeing with anything that's been said by Rufus and the other panelists, but I always like to inject a little bit of dose of political reality. I mean, I do think, to Matt Schaefer's first question about, is progress on sort of fixing the appellate body, does it need to wait for progress on issues related to China? And I would say, again, from the US perspective, I think the answer to that is it doesn't necessarily need to wait, but I think there needs to be progress on that front. I mean, that is a priority for the United States and other WTO members, substantively, but also politically. And so I don't see the US backing away or being willing to make sort of what might be perceived as more academic concessions related to the structure of the appellate body, when it has what it perceives to be as global economic burning issues related to China and the global trading system. So I think that for me is a dose of reality. Like, there definitely needs to be some progress on that, or the other equally important issues, but less exciting issues from sort of the US political perspective, will fall by the wayside.
Thank you, Stacey. So Jennifer's come online. Before we jump to you, ask Terry, Warren, and Ron to also come online. I do have one other question I want to get to from the audience before that, or maybe to help tee this up, but where do we go? What if we don't have a working system of a DSU? Are we reverting back to to a GATT system of dispute settlement, or whatever it would have, dispute resolution, or however we called it? And what would that look like in the future? Or is that is it the Wild West?
have
Ignacio.
Ignacio and Bruce address that.
Yeah, happy to say a word on this. I mean, it's very clear that where we are now is basically where we were in the middle of the Uruguay round. You have the right to the panel. You cannot block the procedure at the moment that you establish a panel. Then, however, you come to the verdict of the panel, and from that moment, all bets are off. You may have appeals into the void. You may have. You basically no longer have a binding dispute settlement mechanism after the panel phase, except for those countries that have agreed to set up this multi-party intervention arbitration agreement that have preserved the appellate function for disputes as among those parties. Now, that's an interim solution, but as I said, it's a fragmented system, and it's going to imply that at least whenever you are managing a dispute with someone who is not a party to this agreement, it's going to be very, very hard. And it's going to, in my view, lead very quickly to escalation of trade conflicts. I mean, I know that the European Union would certainly react strongly if it was going to be facing unilateral action from the United States. And I don't think that we will be the only ones. So my impression is if we do not find a way of fixing the system multilaterally, we are going to have a very, very turbulent period ahead of us, probably much more than in the 80s, because after in the 80s there were conflicts, but there was some greater degree of commonality among the participants that you actually have right now. So I totally agree that we need to fix the China issue, but I don't think that disabling dispute settlement is going to help to fix the China issue.
With that, I'm going to thank you, Ignacio. Remind folks, I know you signed up for 11 to 12 and we're going a little long. We understand if folks want to log off, but we do have some real experts who've just logged in and come online and would love to hear from them. Rufus, do you want to just say anything?
Yeah, no, we'll just go through, obviously each of you to get a chance to make a comment on this, because you've all been working very heavily on this. I know, Jennifer, you've written a great deal in this area and talked about it, obviously, former member of the appellate body and former general counsel at USTR. Terry, as a private practitioner, have done a great deal. Obviously, Warren, also a former general counsel, USTR, and a practitioner in this field. And Ron, of course, your longtime work at the Commerce Department in dealing with many of the issues that we're talking about. So each of you, just 4 to 5 minutes, your general commentary. We're not going to have time for questions or discussions, starting with Jennifer and then just going Warren, Terry, and Ron, okay? So go ahead, Jennifer.
Great, and thank you. And it's a pleasure and an honor to join all of these experts on this issue. I'm going to just start by sort of saying what I heard from this, on the one hand, is very good news, in that it sounds to me as though there's an awful lot of convergence about how to do this fix of the appellate body. Again, I think you heard it in a lot of the papers and the ideas that Bruce is throwing out that match very much, I think, a lot of the 7 ideas that Ignacio has thrown out. And when you couple that with the Walker principles and the work that Ambassador Walker has done, to me, it sounds like we are actually quite close to a substantive package that could be done. And the issue is, can it be done? And I don't disagree with Ignacio's sense that this will only happen if the United States and the European Union get on the same page. And at the same time, I think we have to be cautious that whatever that page is cannot be completely off-putting to China or India or some others. The bad news that I take from it, or at least the thing that my strong cautionary note is on the timing issues. Because I think all of these last comments about the importance of the system have highlighted how urgent this matter is. And at the same time, I will just put on the table, I'm extremely worried about the timing. If you think about the dynamic in Geneva for most of this time, the question that everyone asked, I think all Americans, is the goal of the United States to kill the appellate body, or is the goal of the United States to reform it? And at least for now, I think we got the answer when USTR Lighthizer testified before the Ways and Means Committee, where he said unequivocally, if the WTO appellate body never comes back, that would be fine. That's his direct quote. I don't feel any compulsion to have it ever come back into effect. So at least for right now, as a timing matter, we have the answer to the question that it is the Trump administration's, again, goal, or at least willingness, is to kill the appellate body. So that then begs the question of when, timing wise, can we get serious about a negotiation to move ahead with this? And I think that is going to depend to some degree on the election. The second timing issue that I think we need to think about is the leverage here. I think leading up to recent days, I would argue the United States had a lot of leverage. I mean, they had gotten the attention of the rest of the world to complaints that the United States has been espousing for many, many years, and nobody had been listening. Now everybody is listening. And clearly the whole Walker process to come up with these principles really means everybody is listening and hearing the US's concerns. The concern I have is how long that leverage can last. And particularly if the rest of the world moves on to this multi-party interim arrangement that Ignacio mentioned, where we do have a lot of the big players, you know, the European Union, China, and many others signing on to this MPIA process. To the extent that the rest of the world moves on, I think the US loses its leverage to try to push for the kind of reforms that it's been talking about in terms of the WTO. I understand and completely agree from a practical and a negotiating standpoint why Ignacio is suggesting a two-step process. The concern I would have is how long is that going to take, and whether or not the United States in particular is going to want some assurances on the outcome of the second step before it will actually lock in to any agreements on the first step. And the last thing I would only comment on in terms of this leverage and timing point comes back to where Ken started us, or Ken commented, which is, again, this idea that the United States was very reluctant to agree to this binding dispute settlement system. And I think we all have to remember that. I mean, I think we have to remember the United States does not join any other form of state-to-state dispute settlement mechanisms. We're not part of the International Court of Justice. We do not submit to the jurisdiction of the International Criminal Court or the Inter-American Court of Human Rights, or on and on and on. I mean, the United States is simply not a party to any dispute settlement mechanisms for state-to-state disputes, except for the WTO dispute settlement system. Why? If you go back, I think, and look at it, a lot of members at the time the Uruguay round went through expressed a lot of concern about this. And yet they said, oh, but I like the agreement on agriculture. I like the agreement on TRIPS. I like the services agreement. I like something else that's part of this package. And therefore, I'm willing to live with my concerns about the dispute settlement system, which also, again, begs the timing of whether you can fix the WTO appellate body right now as a one-off, which again would be faster and more efficient and more effective if we could do a one-off settlement to fix the WTO dispute settlement system. But as a political matter, I'm just concerned that the longer it drags on, the more things get attached into this notion of I won't reform the WTO appellate body unless I get fixes in a whole lot of other areas, which then again, I think pushes the timing way out. And again, brings in then the possibility of all the negative things that were just talked about in that last question about what happens if we don't have a dispute settlement system. So my bottom line take is I think this seminar has pushed the notion that this is very doable and very fixable. And a lot of the substantive ideas about how to do it are out there or on the table, and that we are very close to a package that would work. And the question now is whether, as a matter of timing and political pressure, we can move it from where we are now to completing some kind of a reform process as soon as possible.
Thank you, Jennifer. Go ahead, Warren.
Thanks, Rufus. And it's great to hear such a lively discussion. I'm sure this is going to be going on for a number of years because I don't think this is anywhere near a solution. I guess I would start with Rufus's opening point, which is we probably do need some enforcement system if the WTO is going to remain an effective institution or become an effective institution again. And we probably need a multilateral system because there are some things like subsidies that just can't be resolved through FTAs. On the dispute settlement itself, I think we should keep in mind that it's been something of a mixed bag. The decisions on Article 3, on the scope of Article 20 exceptions, on SPS, on TBT, I think have been pretty good and reasonably well grounded in the text and in the understandings that were reached in the round. Where the appellate body has gone off the rails, as Stacy laid out, has been in the anti-dumping and escape clause area. And in there, it seems to have treated these as exceptions and therefore to be narrowly construed. The problem is that the GATT and the WTO are basically political agreements, and they've always recognized that you needed some sort of a safety valve to let off the political pressure. And by clamping down on that safety valve, they've gotten themselves into a horrible fix. The other thing I would say more fundamentally is the appellate body and the whole dispute settlement system has started to assume a disproportionate and outsized role within the WTO system. And it's undercut the fundamental role of the WTO, which has been overseeing trade negotiations. And that's what's really liberalized the system, has brought tariffs down from their Smoot-Hawley rates, set up a system of rules. And now we're sort of bogged down in a bunch of fairly narrow technical disputes, mostly about hammering away at US or European or Canadian anti-dumping laws. But the fact that the appellate body has been so willing to strike down anti-dumping measures has created a major disincentive for some of the developing countries and some of the countries that are heavily targeted by these things to negotiate. And as people have said, there were ambiguities, a lot of them in the anti-dumping agreements, a lot of things that were sort of fudged over. And by trying to fill in the gaps, fill in the blanks, the appellate body has undercut the utility of anti-dumping and countervailing duties as something that would bring a number of countries that are highly problematic to the table. I really don't see any way of doing this aside from around. I think that the Walker proposals are sort of interesting, but they're small change and they don't get at the basic problem of overreaching. And you probably need a larger round to fix and rebalance this whole thing. And we need a round right now because you know, the WTO is floundering around and it's seriously out of date. And I'll stop there. Thank you, Warren. Terry, you want to go next?
Thanks, Rufus. Let me start by commenting on the great job that NFTC has done in terms of getting Bruce to do those excellent papers. And Ignacio, your paper is really very thoughtful and a great help to a broader set of issues than just the appellate body. If I were to comment on the papers, I think that the shortfall from where I see the EU being willing to compromise is in the clarification of 3.2 and 19.2, which Bruce has raised in terms of gap filling ambiguities. And I don't think that you get the United States to a point where they feel that the system will work unless you get some specific clarification there that is not the role of the panels of the dispute settlement or the appellate body to do. Second, on the while there's a recognition, certainly in Ignacio's paper and in Bruce's paper, that the overreaching problem is significant, and as Stacy said, a lot of it is focused in the trade remedies. It seems to me to be not credible that you would get a solution where the overreach problem isn't dealt with not simply prospectively, but retroactively. And the challenge is, how do you do the retroactively? Ignacio has suggested negotiations. He, I think in his paper, identifies that would probably take at least 3 years. You know, I think that Jennifer is correct that it is highly unlikely that you're going to get that as a separate vehicle to get the appellate body back. If you're the United States, the paper I had done, I had suggested that you could, there's a lot of countries who've had overreach concerns, in particular disputes. So there's a question of whether or not you could force the system in a truncated manner to look at those automatically. If a member had raised the concern about overreach at the point in time when the panel or appellate body decision was being adopted, as a way to take it off of the negotiating forum, and at the same time, if you have prospective rules that clarify that gaps are not to be filled, et cetera, it might work. So why don't I stop there?
Very good, Terry. And Ron?
Thank you, Rufus, and as the non-attorney to this party, I guess it's my role to kind of offer some random thoughts. about how to make things better more generally. I tend to believe that DSU reform is dependent on WTO reform overall. And you might be able to sequence it in certain ways, but until you tackle the whole problem, it's not going to be solved in any sustainable way. So when the WTO was set up, it was supposed to have an active program of work across 3 areas: implementation of existing agreements, negotiation of new agreements, and adjudication of legal disputes. And one of the downsides of binding dispute settlement has been for that to be the default response to every trade issue in the system. So as a result, we have an atrophying of the negotiating function, and maybe to a lesser extent, but some atrophying of the implementation function. So I have 3 kind of crazy ideas to throw out there that people can, in the fullness of time, pick apart at their own leisure. The first would be on implementation. Let's look at the work of the committees and standing bodies. There's a lot of sort of informal consensus and convergence building that could be done on how to interpret the rules and how to apply them, particularly in areas like trade remedies, but not exclusively so. Experts groups could be used more fully in some of these contexts to, subject to the view of the members, provide some additional thoughts about how to interpret and apply some of the gaps and ambiguities. And lastly, I think both of those tools can be used to help build up capacity building for developing country members, because these are complex issues and there's a need for the full membership to have a stake in the system and to understand the rules and how to apply them correctly. And in that last regard, I think standard of review with respect to trade remedies is completely related to the extent of transparency and due process that is applied by domestic authorities. And I'm not saying there's a magic answer there, but you have to look at those 2 together. On the negotiating function, I would try to give some thought to how can a more official and robust record of negotiating history be established. My friend Terry has done us all a great service in the Uruguay rounds and Doha rounds by publishing from an outside perspective where the parties were coming from. And I think much like you have legislative history and committee reports to help judges determine the intent of the Congress in reviewing laws, there is a way to kind of more fully develop the legal drafting group that occurred at the end of the Uruguay round, or the statements of negotiating group chairs, all these sort of things where the parties can lay out what their intentions were, and then you can let a judge decide at a later stage where that falls out in terms of an interpretive question. And my craziest idea has to do with adjudication. I see now national security issues, that genie is out of the bottle, and it's going to only further complicate the role of dispute settlement in this system. And sovereignty has always been linked to this question of binding dispute settlement. So I wonder whether, not as a panacea, but as one particular thing to think about, is there a way to kind of look at, I'm not talking about Security Council vetoes, but for parties that are subject to the most litigation, is there a quota on the number of times that they could block adoption of something without sticking up the whole system in its entirety? And they would still be obligated to provide some kind of compensation if they chose to do that. But there's a way to sort of, we have to think of ways of squaring this national security preoccupation in this era of neo-nationalism that we're in now, with having a robust international system that works to everyone's benefit. So that's it from me.
Ron, thank you all. Really appreciate all your input. And I think you've, Jennifer Warren, Ron and Terry, you validated our idea of bringing on some additional voices. This is an incredibly complicated issue. The DSU is complicated. WTO reform, Ignacio, as you were bringing up, there's so many things that we should be discussing here. It came up almost in everybody's comments, the broader WTO agenda, which is something we absolutely need to continue to address and continue to do a deep dive on. Before I close out, I want to go to Rufus for a final comment. I know you wanted to say something. It looks like Ignacio, looks like you're looking to jump in again, but we're pretty much out of time. You're good. Okay. Rufus, you want to give a final comment and then I'll close this out?
Yeah, I just want to first of all say a big thanks to all of the panelists for an excellent presentation. It's hard to summarize everything that's been said, so instead I'll just make a general observation. You know, a lot of you spoke about the need for trust among the parties in order to overcome these differences, in order to have a dispute system that does have effectiveness. You have to have trust among the parties, not only about the dispute system, but about the rules themselves. And the element of trust is very important. Ignacio mentioned that, you know, where we stand now is sort of where we were in the Uruguay round before the adoption of negative consensus and the appellate body. But I have to tell you, I think that the lack of trust is much greater now than it was at that time. I was the US ambassador to the GATT during that period. And I want to remind everybody that even with the ability of losing parties to block panels, some of the major parties, including the US and EU, agreed to unblock panels. I still have the scars on my back from the decision to unblock the Section 337 panel, the panel on leather footwear, and a number of others. The EU unblocked the soybeans panel after we had negotiated tediously in order to basically roll the solution of those disputes into the negotiation of the Uruguay round. So we're in a situation with much less trust today than we had then among major players. Everybody knows there are key reasons for that. The rise of China and the lack of applicability of rules to China, the rapid departure of the US from its previous trade policy, which has created a great deal of mistrust for the first time really in the history of the system, a mistrust of the US in whether or not it's willing to abide by rules, and therefore what is the value of restoring dispute settlement if the US is not going to abide by rules. And of course, a breakdown really between the two players who were always the guiding mechanism of the system because of their commitment to the rule of law, their belief in a system of jurisprudence, the United States and the European Union, and how that relationship gets restored. I don't have answers for how we get back to that level of trust, but we desperately need to do so in order to overcome these differences and restore the system. I've taken a great deal of encouragement from the things people have said today, but let's face it, the task before us is daunting. And I hope you will all stay heavily engaged in trying to figure out this very difficult difficult and complex international negotiation.
Thank you, Rufus, for those words of wisdom. You are a great help to all of us in understanding and appreciating the importance of the multilateral system. And I'm very grateful to you and all your work, both before your time at the NFTC, but certainly now the work you're doing today with your fantastic team there. So thank you for all that. Jennifer, Warren, Ron, Terry, Stacy, Ignacio, Bruce, really grateful to all of you for joining us today. Really fruitful discussion. There's so much more for us to discuss. I know we're going to have a chance to do this again. I'd love to have all of you back one way or another for more discussion, and I'm really pleased to be able to bring more faces on the screen today. So thank you everyone for this. Thank you for those of you who stick around late to stay on this session. We will follow up. We know there were a few questions we didn't get to. We will forward those to our panelists so they can see that and maybe have a chance to respond to you directly. Really appreciate everybody's time. Thank you for being here. Everybody stay safe, and reminder to all of you watching, wear a mask. Thank you.